Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.
People v. Michael Worley, decided on June 15, 2023. Rivera, J. Persons required to register as sex offenders are entitled to the due process protections of notice and an opportunity to be heard before a court determines their risk level classification under the Sex Offender Registration Act. Sora. See Doe v. Pataki. People v. Baxon. People v. David W. See also Correction Law Section 168N, 3. We hold that the Sora court deprived defendant of those basic procedural guarantees when it upwardly departed from the presumptive risk level without affording defendant notice or an opportunity to contest the basis for the departure. 1. In 2012, then 19-year-old defendant Michael Worley engaged in forcible sexual intercourse with a 12-year-old child. He pleaded guilty to attempted rape in the first degree. See Penal Law Sections 110.00, 130.35, 4. And endangering the welfare of a child, and was sentenced to 3.5 years imprisonment followed by 15 years post-release supervision. These convictions required him to register under SORA. See Correction Law Section 168 et seq. Prior to defendant's release from prison, the Board of Examiners of Sex Offenders, the Board, prepared a risk assessment instrument, RAI, and case summary scoring defendant 115 points under various risk factors for a presumptive Level 3 risk classification. As relevant to this appeal, the board explained that because defendant incurred 9 Tier 3 and 10 Tier 2 disciplinary sanctions while incarcerated, it assessed him 10 points under risk factor 13 for unsatisfactory conduct while confined. The board also assessed defendant 15 points under risk factor 12 for refusing or being expelled from sex offender treatment because, according to the case summary, defendant was referred for such treatment but removed for disciplinary reasons. The board did not recommend a departure from the presumptive risk level. At the SORA hearing, the Assistant District Attorney, ADA, initially requested a risk level 3 classification based on the 115 points assessed by the board. However, the ADA acknowledged a discrepancy in the case summary regarding risk factor 12, explaining that defendant was never referred for sex offender treatment because his disciplinary history required him to stay in restrictive housing. Defendant objected to the assessment of 15 points under risk factor 12 and sought to bring his total score to 100 points, for a presumptive risk level 2 classification. Specifically, relying on People v. Ford, defendant argued that his ineligibility for treatment based on his disciplinary history cannot be equated with refusal to participate in treatment for purposes of risk factor 12. The SORA court raised the issue whether Ford contemplated an upward departure from the presumptive risk level based on an extensive disciplinary history. Defense counsel protested that the district attorney never requested a departure and defendant had not received notice. Counsel, by case law he is not. He should not be assessed points on that category. The court, I don't know if that case suggested that the extensive disciplinary history may be a reason for departure. Counsel, the DA didn't ask for it to be a departure. I have no notice of departure. The court, I am not here to do what the DA necessarily asks. The court makes the following findings of facts and conclusions. I find that the people have established 100 points. The 15 points not assessed because he does not constitute a refusal or expulsion from sex offender treatment. But his disciplinary record prevented him from receiving the sex offender treatment. So, based upon the 100 points, he would be required to register as a Level 2 sex offender. However, I do use the extensive prior disciplinary history established by the record for an upward departure to Level 3. I will sign an order designating him a Level 3 offender. Exception to the defense. Defense counsel then asserted that the court could not upwardly depart absent a request from the district attorney. In response, the court stated that it would hear the ADA as to a request for an upward departure. The ADA obliged and requested an upward departure based on defendant's extensive disciplinary history involving 9 Tier 3 sanctions, and numerous Tier 2 sanctions. Defense counsel again objected and insisted defendant was entitled to 10 days' notice. The court concluded the hearing by stating, "The order is signed. You have an exception for the record." The appellate division affirmed, holding that the SORA court acted within its discretion to upwardly depart to Level 3 based on defendant's extensive disciplinary history. We granted defendant leave to appeal, and we now reverse and remit for a new SORA hearing. 2. Prior to an offender's discharge, parole or release, the sentencing court must determine whether to designate an offender a sexual predator, sexually violent offender, or predicate sex offender, as defined in SORA, and apply the board's SORA guidelines to determine an offender's level of notification. Defendant is entitled to a hearing in accordance with SORA's procedural requirements before the court issues its classification decision. As relevant here, the board must provide the sentencing court with its recommendations 60 days prior to a defendant's release. Pursuant to Section 168(n)(3), the court must notify the defendant, their counsel and the district attorney of the SORA hearing date and furnish the parties a copy of the board's recommendations and statement of its reasoning. If the district attorney seeks a determination that differs from the recommendation submitted by the board, at least 10 days prior to the determination proceeding, the district attorney shall provide to the court and the sex offender a statement setting forth the determination sought by the district attorney together with the reasons for seeking such determinations. The court makes these determinations only after 1. Receiving the board's recommendation and submissions regarding the offender designation and risk level classification. 2. Receiving any different determinations, and reasons therefore, proposed by the district attorney. 3. A hearing where the defendant may object to those recommendations. And 4. Consideration of any materials and evidence submitted by the offender and the district attorney. The statutory notice provision was enacted to address the federal constitutional due process infirmities identified in Doe v. Pataki. It is well established that sex offenders are entitled to certain due process protections at their risk-level classification proceedings, Baxan, and the basic hallmarks of due process are notice and an opportunity to be heard. See David W. Proper notice is essential to achieve SORA's goal that an offender arrive at the hearing informed of the basis for the board's and the district attorney's recommendations, and is also afforded an opportunity to challenge the grounds propounded by both. Otherwise, an offender would prepare for the hearing solely relying on the board's determinations, factor by factor and point assessment by point assessment, without advance knowledge of the reasoning upon which the district attorney will rely in support of a different offender designation, risk classification or underlying grounds. That is not due process under law. Indeed, due process requires that a SORA defendant receive sufficient notice and an opportunity to be heard before an upward departure is granted. 3. Here, the proceeding failed to comport with due process because defendant was provided no notice or meaningful opportunity to be heard in response to the district attorney's request for an upward departure first interposed during the SORA hearing in response to the court's invitation. The board recommended the court classify defendant as a Level 3 offender based on his risk factor score of 115 points and did not recommend an upward departure or that the court consider defendant's disciplinary history for purposes aside from a factor 13-point allocation. Although the district attorney agreed with the board that defendant should be classified as a Level 3 risk, the district attorney reached that conclusion not on the total point assessment contained in the RAI but rather on an independent basis that defendant's disciplinary history was sufficiently egregious to warrant an upward departure. Once the district attorney announced its deviation from the reasons supporting the board's proposed risk level classification, defendant was entitled to a sufficient opportunity to consider and muster evidence in opposition to the request for an upward departure. The record shows that the court decided the issue without an adjournment, without allowing defendant to present rebuttal arguments or collect additional evidence, and without any input from defense counsel. The court erred by proceeding in this manner. Under these circumstances, the SORA court denied defendant the due process to which he is entitled. The proper remedy for this violation is a new judicial determination of defendant's SORA classification, made after timely notice of the board and district attorney's recommendations and reasons in support, and upon consideration of the parties' arguments and the evidence submitted at the scheduled hearing. 4. Defendant's remaining contentions are rendered academic. Accordingly, the order of the appellate division should be reversed. without costs, and the matter remitted to Supreme Court for further proceedings in accordance with this opinion. Order reversed, without costs, and matter remitted to Supreme Court, Kings County, for further proceedings in accordance with the opinion herein. Opinion by Judge Rivera. Chief Judge Wilson and Judges Troutman and Halligan concur. Judge Garcia concurs in an opinion, in which Judges Singas and Canatero concur. Decided June 15, 2023.
Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law